Hello everyone. I hope I am audible and visible to each one of you. You can just tell me with a thumbs up or anything just to make sure that I'm aware that you are there. Thank you so much, Harsh, for pointing it out. I'm glad. So, starting with today's webinar, first of all, hello everyone. A very warm welcome to all of you on behalf of Law Learning Bench. I'm Richa Sahai. I'm your host for today's session, and today we are diving into one of my personal favorite topic. Something I truly wish I had better understood during my own law school days. If I had known this, it would have made a real difference for me about how I approach my career so far. So today we are going to explore the critical difference between law in books and law in practice. This gap is something that is very persistent and has been recognized by every legal professional, whether they are aspiring litigator, in-house counsel, or legal professional, or anyone. They can clearly see this gap, and this gap needs to be bridged because then only you can truly succeed in your career. So in law school, we can see that we all learn about the theories and everything, right? I believe everyone can connect with me on this point that we all learn the theories, statutes, and cases. But when it comes to stepping into the courtroom, the reality can be very different for each one of us. Like there can be questions flooded. How do I draft a case? How do I file it? How do I defend myself, cross examine, or even present myself before the judge with composure, with the decorum expected in the courtroom? How should I speak, behave, and conduct? Ultimately, these are the questions which you actually encounter when you are stepping into the real courtroom. Now, the truth is, these skills are rarely taught in law colleges, yet they are absolutely important. And it is not just about the litigators. Even if you are choosing a career which is not about advocacy, like complete litigation, it is about corporate, in-house counsel, or any other legal career. Understanding these courtroom procedures, the skills of drafting, oral argumentation, presenting yourself, and advocacy, all these are always a huge advantage for your any chosen career. I think everyone can connect with me on these points. So that is exactly what we are focusing on today. We are trying to bridge the gap that is existing between the theoretical knowledge provided in the law colleges and the practical advocacy skills which are required for you to function properly as a legal professional in your day-to-day activities. By the end of this session, you will definitely understand the significant difference existing between these academics and practice, but you will also gain the clarity on where you stand as an advocate right now. So what I'm trying to say you is that with this end of this session, by the end of this session, you will able to understand the gap as well as your own understanding, your own skills, whether it is about drafting, whether it is about just being presentable in the courtroom. You will get to know where you stand as an advocate. So I strongly encourage each one of you to stay with us till the end. And I believe this particular session can be a real game changer for all of your careers. So I hope we are connected till now. I can see new more faces and I'm glad about it. Thank you so much, Harsh, for the thumbs up. Now, moving on to our session's next particular thing, which I want to discuss. So, see, before we proceed, I want to have a quick note on this session guidelines. So, first of all, this session is recorded just for the purpose of, academic and training purposes. And apart from that, this sessions contained in materials are completely confidential and are shared solely for the educational purposes. So any reproduction, redistribution of the content is highly discouraged. And lastly, let's have a quick reminder on the house rules. Obviously, there are few house rules. I will really appreciate if you all please cooperate and please abide by these rules. First of all, kindly maintain professional decorum throughout the session. You all are law graduates, law students, so you are completely aware of these decorums. You are welcome to post all the questions in the chat anytime. Our speaker will definitely answer all your questions live in this webinar session only. And even if few questions are there which need to be addressed and they are left because of some reason, because we are moving from one slide to another, anything, then they will be definitely answered by the end of the session. And lastly, please avoid any interruptions when the speaker is presenting. This is something I'll expect from all of you. And with this, we just discussed the house rules and the whole agenda of this webinar session. But I think we need to know our audience as well. You people also should get the chance of talking and just telling us, like, what's your name and the reason you have decided to join this webinar today. So let me start with anyone who want to volunteer by themselves, just to introduce themselves. You can just raise your hand and I can quickly unmute you. Okay, Vaibhav Jain has raised his hand. Just give me a second. Just give me a second. Sir, can you please unmute Vaibhav Jain so that he can introduce himself?
Vaibhavan, please unmute yourself.
Vaibhav, you can unmute yourself on your own. Please unmute yourself.
Hello.
Yeah, hi. Hi,
Hi.
Vaibhav Jain.
Hi.
Welcome to this session. Please introduce yourself.
Thank you. Thank you very much. My name is Advocate Vaibhav Jain.
Mm-hmm.
I have graduated now in 2013 and
Okay.
given judicial service exams.
Mm-hmm.
Now practicing in court. In my court, I
Okay.
I have I have worked 4 years with the Supreme Court AOR,
Mm-hmm.
Advocate and Record. Now
Mm-hmm.
practicing in District Court. And
Okay.
the factor which motivated me to
Mm-hmm.
join this session is I have watched the past recordings of Law Learning Bench, and it is
Okay.
very apt to the point.
Okay, great, great.
And
Glad you are inspired to join this, and thank you so much, Vaibhav, for joining us. And let's move to another participant because we have very limited time with ourselves. So let me get back to some another. I hope that's okay. So
okay,
let's get back to anyone who want to volunteer. Harsh, can you please unmute yourself and introduce yourself very quickly?
Hello, ma'am. My name is
Hi.
Advocate Harsh Kumar Agarwal, and I'm a
Mm-hmm.
practicing lawyer in Delhi, and
Okay.
also practice in various tribunals like NCDRC, Trade Commission, Consumer Court,
Mm-hmm.
and Labor Court. And I
Okay.
have done my LLB in 2021, and
Mm-hmm.
currently I'm also preparing for the judicial service examination.
Oh, great, great. So, what inspired you to join this session?
Uh, I am I joined this session just to get some knowledge.
Okay, great, great, great. Thank you so much, Harsh. Moving on, please. Anybody else want to just unmute themselves? Rijuan, Vaibhav, Vinesh, anyone? That's okay if you are not willing to do so. That's okay. Anybody else? Okay, no worries. So we just get to know each other very quickly, and now we can move ahead with our section. Obviously, no worries about the same. So, first of all, before moving ahead, let me introduce you to the speaker of the day. So, it's given me immense pleasure to introduce to all of you, to our speaker of the day, someone whose journey has beautifully combined legal theory with hands-on practice. So, Ms. Drishti Yadav is a legal research analyst as well as content creator with more than 4 years of professional experience in legal research and domain. She has also has experience in legal journalism and content development. She has graduated from Himachal Pradesh National Law University and has been working with different law firms, edtech platforms, and leading legal news portal. She has even mentored thousands of aspirants for CLAT and other law entrance exam. So basically, she has the combined knowledge of legal knowledge as well as practical insight to guide the next generation of legal professional. Drishti has even served as a judge for multiple national moot competitions and is passionate about bridging this gap existing between academic legal education and real world courtroom advocacy. So, basically, Ms. Drishti is bringing a rare clarity with richness to this session, and this particular whole session is grounded in real experience, accessible to all the learners at every level. So, we are very glad to have you with us, Drishti. Over to you now.
Thank you, ma'am. Thank you, Richa, ma'am. Now, before I begin, can somebody please let me know I'm perfectly audible and visible?
Yes, you are audible.
Audible, audible.
Begin, I would like to tell you that if you get any doubt, you can interrupt me in between. If I am not able to address your doubt, you can just patiently wait and I will try to address all of them at the end of this session. With this, I would like to thank Richa ma'am. Thank you for the introduction. Hello everyone, welcome to this first webinar. Today we will be dedicating an ample amount of time to discuss real courtroom advocacy. We will also be discussing about bridging the gap between law in books and law in practice. As we all know, real courtroom is different from classroom. In court, you don't have the luxury of flipping through notes or for that instance, waiting for a hint from your friend. You need to react in real time, make decisions under pressure, and back them up instantly. So, to get us thinking like advocates rather than students, let me just give you a quick practical scenario. This will give me some idea of your current approach and it will also help you reflect on your own readiness. So let us take up this question. I would request everybody to please participate. I would be discussing the correct answer anyway in the end. So meanwhile, you would be provided 2 minutes. I would request everybody to at least try. The question is, you object during trial relevance. What happens next? Option A, you wait patiently for the judge to decide. Option B, you expect the opposing counsel to stop immediately. Option C, you clearly state the legal basis and explain why the evidence is irrelevant. Or option D, you request the judge to note your objection and then wait for the judge to seek an explanation. Now you are provided with 2 minutes like I promised, and I would request everybody to at least try and answer this question. I will be discussing the correct answer anyway, but meanwhile, within these 2 minutes, at least try. You can answer in the chat box. I can see your answers. Harsh is saying C. Anybody else? Try. Most that can happen is it would be wrong. I said I would be discussing right answer anyway. Try at least. Option C, Rishu. Anybody else with anything else? A, B, or D? We have got 2 people saying C. Harsh. Dinesh says C or D. Good. Wrap-up says C. Okay. Most of you are close. Yes. All right. So the correct answer here is C. You must explain your objection's legal basis and relevance. I hope Vinesh you're listening. You said C or D. C is the correct answer. So raising objection requires clarity, confidence, and understanding of Evidence Act application. For instance, it is now Bharatiya Sakshi Adhiniyam. You can say, for instance, objection reading irrelevant under section 149 of Bharatiya Sakshi Adhiniyam, my lord. That the first question was about objections in trial, a skill that determines how fast and clearly you can respond in court. Now, I want to take it a step further. Advocacy isn't just about knowing law, it's also about reading people, especially the judges. So this next question is about instincts, the kind no textbook can give you, but every good litigator must develop. So whoever did not attempt question 1, I urge everybody to please participate and attempt the second one. This question is, which of the following is a non-teachable but essential skill in court practice? A, memorizing statutes. B, identifying citation errors. C, reading a judge's tone and adjusting your argument. Or is it D, knowing Article 21 by heart? Again, you would be provided with 2 minutes. Harsh is so quick, he says C. Okay, you are provided with 2 minutes. Take your time and try to attempt this one. I can see the same names which have given answer for 1. Others are not attempting. I would request everybody to at least try. I would discuss right answer anyway. Harsh, which of the following is correct as per you? Rishu says C.
Option C, ma'am.
You can answer in the chat box. I can read. Option C, Harsh says. Okay. I hope most of you are done with this question. You have attempted it. So the correct answer is, okay, Vinesh says C. This time, Vinesh, you are most sure and this time you're right. The correct answer is C. Reading a judge's tone and adjusting your argument is the correct answer. Soft courtroom instincts are never taught but often determine outcomes. Now, in this question, other three options are also relevant. They are also important. Memorizing statutes is important. Option B, which is saying identifying citation errors, equally important. And so is option D relevant, which is saying knowing Article 21 by heart. A, B, and D are also important, but the question says which of the following is non-teachable but essential skill in court practice. So as per this question, C is the correct answer, because this is a skill not taught to you in classroom, but you cannot say it is not expected at courtroom. Memorizing statutes you are taught, identifying citation error you are taught, and knowing Article 21 by heart is also something you are taught. But reading a judge's tone and adjusting your argument is something that requires advocacy training and real-life courtroom experience. Now, we have just warmed up with two quick tests, one on handling objections and another on courtroom instincts. Now, let's talk about something every litigator eventually faces: drafting. Drafting is where your knowledge meets your ability to communicate it effectively. In court, you can have all the legal theory in the world, all the knowledge that one can possibly possess. But if you can't put it into solid, clear, and strategically crafted document, your chances drop. So let me ask you something, and I want you to really think about this for yourself. Assuming that most of you are either lawyers, legal professionals, or law students, how many of you are confident enough in drafting a basic legal document called bail? Let me repeat it for you. Assuming that most of you are either lawyers, legal professionals, or law students, how many of you are confident enough in drafting a basic legal document of bail? I have not given any options for this. Vaibhav says he is confident. Vaibhav, we will check that. I have one assessment exercise for you. So I have not given any options for this question because, like, I have given options for the first two questions. I have not given any option for this one because I want you to ask this question to yourself and you will realize your own gaps. Moreover, it will drive you to the solution. The solution is that you require personalized training. The answer to the above question can be different. What is fear for you might be strength for somebody else, and vice versa. Like Vaibhav said, he's good with drafting. He might, I am assuming, he might fear speaking. Somebody else, let's say Harsh, he might be good with drafting, let's say, but he will also fear speaking. So you might be good with drafting, but weak in speaking skills. Somebody else might be good at speaking skills, but weak in drafting. Hence, you require training based on your weaknesses. I cannot force Vaibhav to learn drafting since he says it is already his strong point. I would rather focus on polishing his drafting skills, which he is already good at, and I would focus more on his speaking skills, assuming that he's weak in his speaking skills. Moreover, let's take another example. Maybe now I understand that Harsh is weak in, let's say, drafting, but he's very good at speaking skills. So I would polish his speaking skills, but I would give special emphasis on drafting. I cannot keep Harsh and Vaibhav in the same platform, and I would force both of them to learn drafting because the requirements here are different. The weaknesses I was just talking about, taking example of Harsh and Vaibhav, those weaknesses you will realize once you are provided a courtroom environment with similar stress level, time management requirements, and presence of mind. So this brings me to the very agenda of this webinar. As the title suggests, this webinar is targeted towards providing detailed guidelines for young litigators in India. Now, coming on to my first topic, let us discuss something about your law colleges. Like Vaibhav said, he has graduated in 2021. I am assuming most of you would have graduated within 2020 to 2025. So let us discuss what law school teaches you. I assume law school teaches you a lot about black letter law. Heavy emphasis on doctrines, sections, definitions. I assume most of you by now would have by-hearted memorized section 376 of IPC, which is now 63 of BNS. In law school, there is heavy emphasis on landmark judgments, ratio decidendi. I assume most of you would have by now by heart the judgment in Keshavananda Bharti versus State of Kerala. But I believe most of you won't know the facts or arguments or evidences of that case. Or even if you know, even if you learned that thing once, you won't remember them now. And same goes true for other judgments as well. Let's take an example of Mukesh versus NCT Delhi. In law school, you're taught constitutional provisions and statutory interpretation. I'm sure your teacher would have dedicated not less than 3-4 classes on Article 21 of Constitution of India. And the same goes true for other statutes like I graduated in 2013. Okay, correction. All right, Vaibhav, thank you so much. So I was saying you're taught constitutional provisions and statutory interpretation, heavy emphasis on it in your law school. And I'm sure your teacher would have dedicated not less than 3-4 classes in teaching you Article 21 of the Constitution of India. And same goes true for other statutes like Section 8 of Indian Evidence Act, which is Section 6 of Bharatiya Saksha Adhiniyam now. It deals with motive. In law school, teaching happens in hypothetical problems, on landmark cases. And the chances of you getting a case in your legal career with the same set of facts or even similar set of facts are very bleak. I mean, most of you are practicing, I believe. How many of you have got exact same situation as Keshavananda Bharti, or for that matter, any other case law you have studied? Same exact. Even finding a similar one is good luck, I would say. So in law school, there are topic-specific cases. If your teacher is teaching murder, you will be taught murder cases only, and not the intersection with other subjects like evidence, CRPC. In reality, multiple areas of law work together, and cases are not that simple. In reality, you have to deal with complex web of issues. You are rewarded in your law school for academic precision, not practical improvisation. I hope most of your classmates would be holding gold medals for academic performance. In law schools, yes, there is emphasis on moot courts and internships, but they are limited and confined to particular area of law and cases. Now, then comes the theoretical framework trap. What happens in classroom? Classrooms revolve around rights and duties. Article 14, Article 21, Article 15. Heavy emphasis on maxims like odi altrum partem, actus non facit reum. Definitions from statutes like consent under Section 13 of Indian Contract Act. For that matter, definition of theft. I don't have any issue with that. This is equally important. But my issue is, students are rarely taught how to invoke these in real arguments, when to use which section in an unpredictable courtroom flow, how to think out of the box and be prepared for all facts and circumstances, not just landmark judgments. Also, how to ensure court filing formalities, both offline and online. For instance, we have e-filing portals, and advocates are expected to be tech ready for the same. Now that we have discussed your law school, let us also discuss the real world contrast. What happens in law school? They will ask you, define negligence with case law. What happens in real life, in courtroom? You would be expected. Can you prove this doctor was negligent? And that too with evidence admissible in court. Now, I'm certain that most of you may not even have seen a medical report or a forensic report, let alone analyzed or used one effectively as part of your evidence. Now that we have previously discussed both classroom and real world implications, so let us discuss the exact issue by comparing both. In classroom, there is a heavy reliance in theory, but without practice. In classroom learning, what happens is everything happens in idealized step-by-step format. FIRs are correctly written, witnesses always respond as expected, all laws align neatly, and classroom cases have one right answer. Tell me if I'm wrong, when your teacher was teaching, all of you, all your friends, and you were replying with one correct answer. What happens in real litigation? Real litigation has multiple strategies, unpredictable judges, missing documents, and reluctant witnesses. We call them hostile witnesses. So what law school doesn't teach is that facts sometimes ruin theory. In real courtroom, cases are not problem sets. They are rather puzzles with missing pieces. Now, a very relevant question that must come to your mind is, so how it really works in court? All right, let us take one example of FIR filing. Next slide, please. Okay. So we are taking an example of FIR filing. What law school teaches you? FIR must disclose a cognizable offense. But what really happens in court? Police often refuses to register an FIR, sometimes citing vague reasons. You must draft a clear, legally worded complaint, attach preliminary evidence, and sometimes you also have to move Section 156, Clause 3 of CRPC, which is 175, Clause 3 of BNSS now. As per this section, a magistrate can order the police to register your FIR if the police have refused to register it earlier, but you have to convince the magistrate first. Even magistrate may ask for proof of at least an attempt to file an FIR before. What I'm trying to tell you here is, in real life, you need strategy, not just legality. In real court, FIRs sometimes get rejected for minor formatting issues. The lawyer sometimes argues just to get the FIR registered first. Now, coming on to Webhub's favorite part, I have one assessment exercise for everyone, including Webhub. Now, coming up to our next topic, I have created an assessment exercise for you. I would request everyone to at least try and complete this. You will be provided 15 minutes to complete it. Once completed, you have to submit it via the Google form shared with you here as well in the chat box and also on the WhatsApp. And I will get your answers evaluated by my team. My team will submit your evaluated copies in this session itself, and we will discuss the solution in the end of the session. Hence, I would request you to stay with me till the end and realize where you made a mistake. So, the assessment exercise is, I would repeat it for you. Do let me know if it isn't clear. You can tell me in the chat box, and I would be more than happy to repeat if at all you miss something. All right, the assessment situation is, your client, Rohit Sharma, a 29-year-old software engineer, has been arrested by Delhi police for alleged offenses under sections 420, 467, 468, and 471 of IPC, which are 316, 334, 336, and 338 of BNS respectively. He is accused of forging salary slips and PAN details to obtain a 45 lakh home loan from HDFC Bank. Arrest has been made without issuance of notice under section 41 capital A of CRPC, which is 35 of BNSS now. He has been in custody for 6 days. There is no prior criminal record. He is sole earner of his family, and he also has elderly mother with chronic illness. Now, you are to file a regular bail application before the magistrate via the e-filing portal. Requirements here are, first, you have to state effective bail grounds. Second, you have to list at least 3 essential documents to attach for the filing via e-filing portal. And 3, you have to anticipate at least one likely objection either from the prosecution or from the court, and you have to prepare your brief response accordingly. Please submit your answer via the Google form shared with you. I would request everyone to please participate and submit your answers. My team will review them. Also, I urge you to stay connected till the end because I will be discussing the model answer for this. You have 15 minutes. It is 12:04. Let's assume it is 12:05. So I will see you around 12:20, I guess. That would be sufficient. 12:22. Let's take 12:22. In order to understand you better, in order to assess you better, it is important for me to have your evaluated copies. So I request everyone to participate. This is not real courtroom, nor is it your law school. I will not announce any marks. You will be provided with personalized guidance and a one-to-one session based on your performance. Hence, I see no reason for you not to participate. Remember, what is difficult for you is going to be difficult for everyone. Please submit your solution. At most, it may be bad, it may be wrong, or it may be blank. But attempt anyway, so that when I discuss the answer in the end, you will realize where you went wrong and why. Okay, so your time starts now. I will see you at 12:22. That would be fine, I believe. All right.
Yes, yes. Yes,
Oh,
yes.
okay, sure. Please try and attempt this one. Let me leave you with that slide where the problem is so that you understand. Richa ma'am, can you please stick to the slide wherein the issue is discussed?
Yeah,
Before that? Yes, this is the one. All right, guys. Vaibhav, I would be specially waiting for your evaluation since you answered you know drafting way. I would request everyone else also to please participate because my team will be evaluating and you will also be realizing what your mistake was when I will be discussing the model answer. Please participate. No issues. If you can be wrong, it can be blank. That's the entire purpose of this webinar. There's nothing rare you're going to do. There are many people who do not understand. But what makes you different is you're going to try this time. And that's the first step towards your efforts. So please try. You have to submit your answers within these 15 minutes. You can let me know once you're done. Whoever finishes before time, just please let me know here in the chat box. There are three things required. First, you have to prepare effective bail grounds. Second, you have to list three essential documents to attach for filing via the e-filing portal. And third, you have to anticipate one likely objection from the prosecution or court and your brief response. Here, I would like to give you a hint. First point should take most of your time. Second and third can be dealt with easily. They are technical and there is no wrong answer, I would say. Basic documents. E-filing portal does not have anything extraordinary. Most of the documents are something you should be knowing when you're practicing. And anticipating one likely objection, it can be different for everyone. I have no sure sort, not expecting everybody to write the same thing. Same goes true for effective bail grounds. Try to apply your strategy as well as your legality. How many of us are done with at least the first point, which is effective bail grounds? Anybody who's done with this one? You can let me know in the chat box. Harsh is done. Well done. Harsh, you're working on the second one. List 3 essential documents to attach for filing via the e-filing portal. I'm assuming if you're not replying, most of us are still stuck with first point, effective bail grounds. Except Harsh. Harsh is on point 2. Not familiar with e-filing. No issues, Weber. Nothing new. Everybody goes through the same what you're going through. I'm going to address it later. I just wanted to check this also, and I just wanted honesty. Since you have been honest, thank you so much. This is going to be my next topic to discuss. A lot of us would not be familiar with a lot of things, and that's all right. This is why we have this webinar. How many of us are familiar with e-filing portal? If not used it, at least are aware about it, something about it. You can let me know in the chat box. Harsh has used it. All right. Webber, you can skip second. You can not able to submit form. Ma'am, can you please look into the issue? Harsh is not able to submit the form.
Just give me a moment. Huh? I'm looking into it.
Error in mobile number box.
Have you entered the 10 numbers or 9 one also? Just try to include that 10 numbers of yours. Then I believe it won't cause any issue to you. Please try once again. If you're not able, then please convey us.
Webber, you can skip second since you're not familiar with e-filing portal. Anyone who's not familiar can skip second. I will discuss it later. You can work on third. It should be easy. Error. Harsh says there's an error.
Just give me a moment, huh? Just give me a moment.
Harsh, were you able to answer all 3?
Please try submitting it before again because I just tried. It is actually taking from my end. So there is no error from submission point. So please try once again to just refresh the form and try to put everything again. I believe there can be some sort of technical issues, but right now it is working.
Muhammad Rijwan, are we able to solve all 3 or at least get an idea about all 3? Rijwan? I just want to know how many of these, out of 3, how many are you able to attempt? At least attempt. Vinesh, are we able to solve all 3? Rishu, Webhub has already told me. Vinesh, unable to submit. I'm submitting my response here. Sure. Same issue, ma'am. Webhub is also facing the same issue.
No worries, you people can just, answer your, just copy paste your answer here and I'll look into it and collect it. Don't worry. Just put it on the chat box. Like Harsh has done, na, grounds and everything. Similarly, you can just post it here and I can take it.
Vinesh Rijwan, I believe you can hear me. I'm audible, I believe. All right, perfect. If you're facing any issue, you can submit at info@lawlearningbench.com. Just to have a perfect experience of a real classroom, we also have a few people like backbenchers. All right, I am assuming most of you are done with these questions. I can at least confirm for Harsh and Weber. I really appreciate it, guys. Harsh and Weber, thank you so much. And I will get them evaluated on priority. Sent on email as well. All right. Weber, you can also send on email. All right. Moving on, it has been not 15 minutes, but I believe time was sufficient for most of us. I remember Harsh doing it around 12, 11, I believe. Weber was also not late. So I believe most of us have submitted our answers for the evaluation. Nevertheless, the problem, most of us have submitted, yeah, the email works perfect. So my team will be evaluating your answers, and soon I will have your evaluated copies. If you could not attempt the question or the time was insufficient for you, you do not have to worry. You can submit your answers after this session at your convenience. I will still get them evaluated. Meanwhile, I would take 5 more minutes and would urge you to stay with me for some time so that one of our experts, Richa ma'am, can explain to you how an advocacy training course can bridge gap between courtroom and classroom. Over to you, Richa ma'am.
Thank you so much, Mrs. T. And thank you so much, everyone, so being so participating and so indulge in this session. And I hope you people are enjoying this session as much as I am doing. And very special thanks to Ms. Drishti. She has been till now guided us very beautifully about this gap. And even the assignment was, I believe, quite interesting for all of you and kept you engaged. And you got to know about your skills and the things you are looking for. But coming to the very theme of our webinar session, which is the persistent gap existing between law college education and the real life courtroom practice. See, it is something every young legal professional feels at some stage. We can see that our participants were earlier saying that they are not able to understand the e-filing. They haven't done it yet. So most of us are at this stage. Most of the law graduates, even the third year, fourth year, who are still thinking of pursuing any such career, they experience the similar thing even after passing the law. Because the fact is, you do not get to see all these things which are the day to day activities. You do not get all those things in law school. Law schools do provide you the essential foundation, and it is very important for you to have a complete legal knowledge. But having only theoretical concepts and legal principles won't work in your legal career. What you need is you need more to success in legal profession than what is just taught in the classroom, which also Ms. Drishti was conveying you in her own way, obviously. So at Law Learning Bench, we recognize this challenge, obviously. We have worked very excitedly and very long time for this particular course, and we have designed the Courtroom Advocacy Skills Training Program. So let me introduce you to this Courtroom Advocacy Skills Training Program, and I hope you people are enjoying the session and staying connected with us. So coming to this course, Courtroom Advocacy Skills Training Program, this particular course is focused on bridging the gap which is existing between the academic learning and the demands which you face when you pass the law course. Like you have just graduated the law course, or you have done post graduation and you stepped into the courtroom. Now here there are many demands which cannot be met by you even if you are the brilliant student in your batch. I think all of you can connect with this. We can see that there are many things which is beyond textbook. So our program is focusing and going beyond this textbook knowledge. They are trying to put you in practical training with courtroom virtual simulations, drafting exercises, hands-on workshop, and these all are led by experienced advocates and judges. So coming to the features of this course, this is a fully online course, and the reason being online, very easy. We wanted it to be accessible to each one of you, because we know if we put down in offline format, in that scenario it will be bound to some geographical location only, and we do not want that for now, and that is the reason we decided to launch and have this course in online format. So it is an online interactive and skill based course which has a duration of a total of 12 weeks. So in these 3 months, the course has a structure which provide you not only high quality learning materials, but also one-to-one interactions. See, when you are talking about training and all now, only having theoretical knowledge or one-way delivery of the lectures from the faculties won't help you. We all know that it has been in there in our law colleges. So our program is focusing on not only providing the structured learning material, but also personalized one-to-one mentoring. You will be learning from those who have been in your shoes. They were there at your position where you are feeling clueless, you are not aware of e-filing, you're not aware of drafting, oral advocacy, argumentation, cross-examination, anything. There are many others who are not skilled advocates, former judges, but they were also sometime in their career at that position, and we have them as our faculties. So you will be connecting with Supreme Court advocates, sitting and retired former judges, and the seasoned legal experts. Along with that, you will also get mentor support. So basically, in weekday sessions, mentors who are mostly the legal experts will be there with you. And apart from that, the live faculties and guest lectures. So apart from live faculty sessions delivered on Saturday, Sunday, when you are basically free, most of you will be available on those times. Even if you are pursuing full-time career or you are still in the law college, I believe you will be available in Saturday, Sundays. So you can have live sessions, live faculty sessions, interactive based sessions on weekends. And apart from that, there will be guest lectures as well, which will be offering you special insights into their respective specialization. So say criminal law, drafting FIRs, navigating areas of tricky areas of practice, all these will be in the faculties, the guest lectures will be enlightening you with all these aspects which are mostly untouched in the law colleges. And now coming to our modules. I hope till now everyone can connect with me and I'm audible and visible to each one of you. So now coming to the modules of our course. On your screen, you can see there are 12 modules. And as I conveyed you, their whole course is of 12 weeks only. So each module will be completed in each week. And in this module, for example, say the very first, Introduction to Advocacy and Evolution of Advocacy. Now, in this module, you will not only have live sessions with the faculties who are experienced of their own field, but apart from that, there will be practical assignments. Now you will be saying, how come practical assignments is going to assist me? See, these practical assignments will not something be take away home exercise like you have to do something in written form. You will be given a case studies, assignments, which will put you in the shoes of the advocate, the defense, the prosecution, so that you can have the skills of those legal professionals. You can be able to present those cases or whatever you have been handed over as the assignment. And then there will be a set of experts, mostly the former judges and senior advocates, who will provide you the valuable feedback. Now when they will be providing you the valuable feedback, when you are performing in a courtroom like situation, there is a courtroom like setup, you are playing the role of some defense advocate, prosecution, or any such role. In that scenario, you will be getting the constructive valuable feedback from those who are already, who have been in this domain for quite a long time. So obviously you will receive structured learning as well as hands-on exposure training that will help you not only to understand each concept deeply, but will also provide you with the idea how to apply the concepts, theories effectively into the day-to-day courtroom advocacy. So I believe till now you can connect with me. Now coming to the features, like one of the very special and unique feature of our course is that you are getting the opportunity for sustained mentorship. I just conveyed you that you will be having one-to-one mentorship in the weekdays as well, apart from the live faculty sessions. So basically what I'm trying to say is the course duration is just 3 months, right? You will be courtroom ready advocate in next 3 months, but apart from that, you will also get mentorship from our experts for the next one complete year. So if you are having some questions, if you are having some case, you have some doubt, whenever it is possible for you, you can reach out to us. You can connect with our expert. They can guide you and assist you as much as possible for them. So they will be providing you continued guidance available till next 1 year. And apart from that, all the enrolled students in the course will also receive free access to all our exclusive webinars during this period. So coming to the whole thing, that by the end of the course, what you are getting. So first of all of you will get certificates definitely, but the top performers will not only get certificates, but they will also receive letter of recommendation. We all know how much important resume is and how much it is important to have some recommendations in your hand before entering into a real legal career, right? So NORs will be also there apart from certificate, and ultimately you will be transformed not only from being a law student or a law graduate to into a real advocate who is able to handle every case, everything, every challenge coming up in his legal career with confidence. So we are dedicated to help you with all these things. And I can assume, I can just conclude this whole thing in two lines, that you are seeing the dream, we are trying to bring it into reality. So we are building the path for you so that you can just have, you just get enrolled with us. Your dreams are to be a very famous advocate or just a very good legal professional who has knowledge of all these areas which are not taught in the law school. So we are trying to bring all these into reality. This is our focus, and I hope you people get to understand the course and the whole curriculum and everything. So now I will be handing back things to Ms. Drishti, and she will be guiding you with the model answer of the assessment she provided you. So over to you, Drishti.
Now, meanwhile, ma'am was discussing about the gap between courtroom and classroom and the advocacy training program. I could go through some of your answers and the evaluated copies. Rest of you, I would request you to submit yours as well so that I get them evaluated. You can get that. You can send those to us even after the webinar. So I can see few of you scoring close to average, some below, none scoring above that. Like I said in the beginning, I'm not shocked, and this is not your mistake. This is ground reality for the majority of young lawyers and litigators. Now, coming to the solution to our problem, the assessment exercise, I would urge everybody to stay connected so that you can understand your mistakes and weaknesses while I discuss the model answer. So we needed bail grounds. We needed a culmination of legal as well as strategic grounds. We can say there is no prior criminal antecedent. The accused, who is my client, has no prior FIRs or charges and is a first-time offender. We can also say all material evidence is already with the investigating agency. For instance, documents like forged slips and email traces are already recovered. Hence, no custodial interrogation is required anymore. Regarding violation of section 41 capital A of CRPC, which is 35 of BNSS, we can say arrest without notice is against Satyendra Kumar Until versus CBI 2021 judgment, where the Supreme Court emphasized that arrest, especially in non-heinous offenses, including many economic offenses, must comply with safeguards under section 41A of CRPC, now section 35 of BNSS, and should not be made routinely without following due process. We can also talk about social and financial roots in society. We can say the accused, who is my client, is a permanent resident of Delhi with dependents there. This reduces his flight risk. We can also conclude by saying he's willing to comply with all the conditions, including surrender of his passport and appearing for investigation if and whenever required. Now comes the second point, which was mandatory documents to upload via e-filing portal. And Vaibhav said he's not familiar with e-filing portal, and I also told him it is a case with most of us. Not all of us are familiar with this. This is the case with a lot of young litigators in our country. Harsh said he has used it. Okay, so mandatory documents to upload via e-filing portal. First, you must have wakalatnama with proper advocate signature and client consent. Second, you must have certified FIR copy to allow judicial scrutiny of accusations. Third, you need affidavit of the accused verifying the contents of the bail application. Fourth, there is a bonus document that I would like to discuss and I would like to give you a hint about. You can also attach medical certificate of dependent mother. This supports humanitarian ground, but only if it is supplemented with substantiate proof of dependency. So for instance, you can attach, let's say, income affidavit, or you can also attach age certificate. Apart from these documents, you also need memo of parties, index, court fee receipt, and list of documents. Now coming to the third part, third and last, likely objection and your ideal response. Likely objection can be forgery of financial documents amounts to economic fraud and is a serious offense affecting public trust. You can say, yes, but as held in Arnesh Kumar vs. State of Bihar, 2014 judgment, and Satyendra Kumar Antil vs. CBI, 2021 judgment, custodial arrest is not the default approach in economic offenses, unless absolutely necessary. Here, the evidence is documentary, already secured, and my client is cooperating. So now that we have discussed 1, 2, and 3, and I hope Vaibhav is also clear about the e-filing portal, and Harsh would also recall. And everybody else is also paying attention, I believe. Now let's talk about what law school ignores. We have taken an example of what happens in law school, what happens in reality, and we have also taken a few real life examples like FIR drafting, and now we have discussed bail and objection practice. Now comes the time when we must ponder upon. Let's talk about, let's say, what law school ignores. So let us take the same example, bail and objection practice. In bail hearing, let's take an example. What law school teaches? Bail is a right except in heinous cases. What happens in practice? Your bail application is returned for sometimes missing surety details, absence of certified FIR copy, improper jurisdiction mentioned. Here the court wants ground for arrest, flight risk, antecedents, recovery status, not just legal definitions. Hence, you must frame a compelling narrative. Regarding raising objection in trial, let's say law school says objection can be raised under Indian Evidence Act, which is now Bharatiya Sakshi Adhiniyam. What happens in court? You must anticipate improper questions live. You must say objection, leading question, irrelevant to fact and issue, and then justify it instantly. For instance, you can say objection, leading irrelevant under section 149 of Bharatiya Sakshi Adhiniyam, my lord. If your objection is vague, the judge will ignore you. There have been a lot of real life instances where the junior advocates, they get reprimanded for objecting without citing relevant sections. So what this teaches you? This teaches you importance of strategic grounds over copy-paste templates. This teaches you procedural compliance, like we discussed 41A of notice, 41A notice, which is 35 of BNSS. We discussed registry filing format. We also discussed e-filing checklist. We also discussed law in action, how landmark bail jurisprudence applies practically. For instance, how strategically we took two judgments, one from 2014 and another from 2021. By taking a judgment from 2014, we are conveying that there is nothing rare that my client is doing, since similar issues have been dealt with by the court ever since 2014. And by taking a judgment from 2021, we are conveying that this issue has been in vogue and is still prevalent. This way, you have traced the origin and connected it with the recent scenario. I want you to know that when you're researching any topic, there will be plethora of judgments, and your expertise lie in strategic selection. Like we did, there must be thousands of judgments on bail jurisprudence. We strategically took two. Your skills lie in conveying a bigger message with few words. We also learned something about use of supporting documents to preempt denial. For instance, we used medical certificate of that dependent mother, if you remember. We also used proof of dependency. For instance, I told you, you can either use income certificate or you can also use age certificate. Then we discussed surrender of passport when we said he is cooperating. There is no need to keep him in jail. And we also discussed affidavit. Now, I would like to give you a reality check. We have discussed everything from law school to real life courtroom to what happens to junior advocates to where are the lapses to where when we can fill a gap. Now, let us talk about something about reality. So, let me give you some reality check. Law schools and courtrooms are very different. There's a myth that you learn by practicing, but without proper courtroom training, you are left to find your own path. And in this situation, first generation lawyers are most affected. When you join any chamber as a fresher, you are still expected to have some knowledge of the courtroom rather than just legal knowledge. There was a time when young lawyers used to struggle, but technology was not that advanced as it is today. Today, you have training courses to bridge this gap, something Richa ma'am was talking about. Law is an evolving area. It cannot remain static. And you, as an advocate, you're expected to evolve with the evolving landscape. Virtual hearings, they started as a safety measure during the pandemic, but they have become a part of courtroom advocacy due to technological convenience. And with its evolution, we are witnessing multiple instances of contempt, disrespect by even many senior lawyers. It's not that they do not know the courtroom procedure, but the problem is they are not trained or they have not learned the adaptation to technology in their law schools. This technology adaptation is new to them. They were never prepared for it in their colleges. Now that the world is preparing to transition towards AI, you must know there are a lot of AI apps specifically targeted towards lawyers to ease their legal research. And this is not something the courts are unaware of. Recently, the Kerala High Court released a policy regarding the use of artificial intelligence tools in district judiciary to steer AI adoption. And this policy covers all AI tools, including generative language models, any devices, including court PCs, personal laptops, smartphones used in judicial work. As per the policy, only AI tools formally approved by the courts may be used for judicial tasks. What I'm trying to convey to you is a lawyer not well versed with legal research tools, AI preparedness, e-filing procedures, and virtual courtroom hearings is going to have a hard path. Let's talk about litigation and its prominence. I remember somebody mentioning they are preparing for judiciary. I believe Weber was the one. Am I right, Weber? I remember somebody mentioning they are preparing for judiciary, but they were interested in attending this webinar. We need to know that litigation is gaining prominence with recent judgments like mandatory practice for judicial officers, corporate lawyers returning to litigation, highlighting the trend and relevance of the litigation and the prominence it will hold in upcoming years. For these reasons, you must ensure you're updated, prepared, and courtroom ready. You require practice first, not theory only approach. Most litigation training programs repeat law school lectures, but you require what courts actually demand. This includes drafting, filing, arguing. You require a real courtroom simulation from live bail arguments, FIR drafting, and objection drills. You deserve to learn from those who have been in your shoes, something Richa ma'am was discussing, who once stood where you are. And just like you, they were also confident in law, but they froze in courts. You need guidance from their years of experience and how they navigated these challenges. Also, you require continuous learning and mentorship that stays beyond the first case. You also require exposure beyond the bar and engage with not just courts, but also psychologists, police, policy advisors, and judges, because law interacts with society, not just the statutes. Extra hard work is obviously required for the first generation lawyers because the truth is many first generation lawyers lack the support others get. Most of us who are first generation lawyers would be able to connect and agree with me. Moreover, you need to be tech ready as well these days. And for that, you require tech ready advocacy training to master, let's say, e-filing, something Weber was saying he was not aware of. virtual hearings, and cost list navigation. Skills most law schools ignore, but courts expect. You require personalized training and mentorship. There is no one size fits all model. Harsh said he's familiar with e-filing. Webhub said he's not. I cannot put both of them in. All right. You can stay for 2 more minutes. I'm about to finish. I am concluding only. So both of them are different. I cannot apply a one size fits all model to both of them. Every lawyer is unique, I believe. Lastly, I would leave you with these questions that you must ask yourself. You will receive your scores along with your evaluated copies by Thursday. If you could not submit your answers within those 15 minutes, I would request you to please submit them after this session based on your strategy, based on the strategy that I discussed, and I will get them evaluated by my team. Thank you for joining us. I hope it was worth your time and you earned some valuable insights. If you have any questions, I would be more than happy to address them. And if you have any issues like WebHub does, you can leave. All right, I'm
I
assuming
believe,
no questions for me.
yeah, most of them have understood everything. They have no questions till now. No.
WebHub, Rizwan, Harsh, Vinesh. Vinesh has been silent all along. Harsh is good. Thank you, Harsh. Thank you so much. I appreciate it. Okay, I'm assuming no questions as of now. It's all right. You can give it a thought and come back later. We will have many webinars. Thank you so much, Vaibhav. This is going to be of really great help. Risha ma'am, we should take a note of it
Yeah,
on
surely.
Vaibhav's demand.
Bilkul. So thank you so much, Ms. Drishti. And we have surpassed our timeline a bit, but I believe it was a very engaging, very informative session from the end of Drishti. And she has guided you and made you understand about the topics she discussed and everything that is existing in the present legal career domain. So for now, for being so good audience and for being so encouraging, thank you all for your time and attention. And I really appreciate that you have been here till the end of the session, and we can clearly see that you have been showing. Sorry, Vaibhav, what are you saying? Through a poll offered by you. Okay. We will get back to you, Vaibhav. Let me just complete it and we will quickly get back to you. So I was saying, thank you so much, everyone. And we can clearly see your commitment. You have been here till the end of the session. So, as a token of appreciation, because you are here with us till the end, we will be sharing some exclusive additional learning material along with your your assessment and their feedback. And we are focusing on providing this additional material with the idea that it will be helping you to deepen your understanding, get get better clarity of the topic that has been discussed in today's session. So feel free to go through those additional materials. They will be shared very soon to you via email, and feel free to go through them. Give your own time, own pay on your own pace. And if you have any doubts, any concerns, anything that you want to discuss, whether it is just about your career, whether it is just about the topic we have discussed, or whether you want to understand about the course we discussed, you can reach out to us through call, through WhatsApp, or visit our website. And apart from that, if you have any specific concern with respect to your career approach, your skills, where you are standing as an advocate, you need some sort of assistance with respect to the queries of the course or any such thing, you can simply scan this QR code and book a available convenient slot as per your availability, and one of our expert, our mentor, will sit with you, will try to assist you as much as possible in their own ways, as much as possible for you, and as well possible for your career as well. So you can just scan this or just note down these details, contact details, and we can connect, we can sit together and discuss each and everything which you are going through, whether it is about just the concept, just the topic, or just the career you are going to approach in the future. Thank you so much, everyone. And it's been a delight to host this particular session with Drishti and all of you by side. And I believe she has been able to connect with you very beautifully and made you understand the concepts and the things discussed very beautifully and clearly. Thank you so much, everyone. And I will suggest if you people are still there and you are, continuing with us, I will ask you just a small request. Can you please just switch on your camera so that we can have a, together selfie? Because this is online, we can have a together selfie at least. Can you please quickly just switch on your cameras if you are comfortable? If not, that's completely okay. Anybody willing to do so? Okay, so it seems. Oh, no worries, Harsh. That's okay. I can understand you people are joining, and that's okay. That's okay. No worries. I can have a screenshot of this particular session this way only. That will also work. So, thank you so much, everyone, and have a great day. We will be meeting with you again in the next weekend with some another topic, and one of the topic that was suggested by Vaibhav. Vaibhav, you can mail us the topic or reach out to us and connect whatever topics you want to discuss. We will try our best that we connect, and we have this session for all of you on that particular topic so that you can have a better understanding on those things. So we will be connecting, I believe, in the next week with another topic, with another speaker, with another guest lecture. So thank you so much. Until that time, please be connected. Please reach out to us if you have any queries related to career, course, or anything. Thank you so much, everyone. And I have a very, very good day, good Sunday. Thank you. Bye bye.